Well, the first thing to say is, how is the temperature, Miss Hooper?
Much better than yesterday. Thank you
Yeah,
very much.
and the experience of this court is that sometimes it can get very cold when the air conditioning is going. So please, will you let us know if the temperature is uncomfortable either way.
I will do, thank you.
Thank you very much for all the material that you've sent in recently. The most recent being the authorities, which Mr. Payne, I think that was the most recent documents, the two authorities on the cost point. I mean, it seems to us that there are three matters, obviously, we've been thinking about. The first is this appeal academic? That's one thing we'd have to think about. The second is, what are the cost consequences? And the third, obviously, is the substantive issues. Our current thinking, Ms. Hooper, is that we'd like to hear argument on everything, without necessarily indicating that we're going to rule on everything. Because whilst we could take a more robust view on the basis that the appeal looks academic in lots of ways, it's not, certainly from my simple way of thinking, not so clear that we are confident enough to shut you out completely. Now, do you want to say anything about that?
I'm grateful for that indication.
I mean, you presumably are happy with that course.
I would be happy with that course.
Mr. Payne, do you have any observations to make about that course?
I'm very happy.
Okay. Well, on my part, I shall take a vow to try not to perhaps interrupt as often as I might if we were just going full steam ahead, but I can't promise. Let's see where we go.
My Lord, the only thing really is the order, and given the indication, the order of points, given the indication that you've just given, I propose to deal with the substantive issues first.
I think
come
that,
on
Lord,
to
yes.
other issues afterwards.
It came out the wrong way. It should be substantive academic costs in that order, I would have thought.
That's right.
Okay, all right? Okay, off you go. We've read, can I say that I think we've all read everything, the substantial documents. So you, and you can assume that we're pretty much up to speed on that, although some of us aren't as familiar with this territory as others. You'll have to bear that in mind. Yes?
So my proposal will be to set out the facts and then to look at the Dublin regulation and then to put the argument about what that means for this claimant and appellant. And fundamentally, this is about the interrelationship between Article 3 and Article 17 of the Dublin regulations. So by way of background, the appellant's case is that although he accepts that under the terms of the Dublin regulations, Italy was originally the member state responsible for his claim, more particularly for examining his application for international protection, which is the phrase used in Regulation 2, Article 2 of the Dublin Regulation. Responsibility transferred to the UK on the 6th of June 2016, when, by way of derogation from Article 3, the UK decided to examine his application for asylum in the United Kingdom as evidenced by the letter of that date, which says explicitly, we have arranged an interview for you to discuss your claim for asylum, eligibility for humanitarian protection, and human rights claim in the United Kingdom. And my primary submission is there's no other way of reading that than it is a decision to examine the claim for asylum in the United Kingdom. That's what it says on its face.
Could you give me the page reference just for that?
Yeah.
The page reference for that decision, which I am going to come back to.
If we're going to come back to it, don't worry.
This is your headlines. Okay.
This is my headline.
I think we'd like to look at that document quite carefully in due course. Yep.
Following that document, the application was then examined on the 17th of June 2016 substantively in the form of a fairly lengthy interview that started in the morning and didn't finish till lunchtime. The decision to consider the claim in the UK had been communicated to the appellant, and then at a later date, somebody else acting for the Secretary of State appears to have changed her mind, refused the claim on the grounds of transfer to Italy, and detained the appellant as a torture victim, causing a psychotic breakdown. So that's the background. And the Secretary of State's case has changed at various points in time. But
Sorry to interrupt so early in your submissions, Ms. Hooper, but can I just ask one question? Was there any evidence before Mr. Justice Murray about this apparent change of heart by the Secretary of State?
my next heading is no evidence.
Oh, right. Okay. I'm so sorry. I should have kept quiet.
my submission
There
of
we are.
this.
Okay, no evidence.
No evidence.
Okay, so point 2.
Is that even at this point, after 6 years of litigation, and notwithstanding the fact that this point was raised by the appellant directly in the response to the stay application on the 30th of October 2017, there is still no evidence as to why the decisions were taken. What you have is a footnote in counsel's skeleton argument.
Okay,
And in
you'll take us to that as and when, will you?
That's frankly not good enough. Particularly when the basis of the case is that this is a decision, of the Secretary of State's case, is that this is a decision that was either not operative, or was made without considering the Dublin regulation, or was a mistake.
So your point is that this letter that you've told us about is evidence of a decision to exercise the sovereignty clause, and there's nothing to rebut it.
Effectively, yes.
Yeah.
And I will also talk later on about what's meant by the sovereignty clause,
Sure.
because I think that's misunderstood quite often, and
That's just shorthand.
and it has a meaning that isn't you have to exercise your sovereign discretion to accept responsibility for the claim,
Yeah.
but you are allowed to.
You're allowed to, yeah.
Examine
absolutely.
the claim.
Come back to that later, please. Yes?
So I would gratefully adopt the formulation of this by Lord Justice Popplewell in the grant of permission, and that's at A1 of the core bundle. And in terms, the issue is whether, once a decision that's been made to examine the merits of an asylum claim, which itself is a decision to examine an application for international protection within the meaning of the first paragraph of Article 17.1, and my understanding is that it's not disputed that it is a decision to examine an application for international protection. It's just disputed whether it was taken for the purposes of Article 17.1 or whether it triggers the transfer of responsibility. That decision to examine the claim is necessarily a decision by way of derogation from Article 3.1, which otherwise mandates who is the responsible state, such that it's a decision to conduct such an examination pursuant to this paragraph within the meaning of that term in the second paragraph of Article 17.1. And that, in a nutshell, is really what this case is. The act of examining the claim, which was an act the Secretary of State was permitted to take, have the consequence of transferring responsibility to the UK. And the appellant says it did, the Secretary of State says it didn't. And secondly, even if it did, she is entitled to rescind it. So in terms of the facts of the appellant's claim, he arrived in the UK on a lorry on the 3rd of February 2016 and attended the asylum screening unit, was fingerprinted and claimed asylum. That's at 312 of the bundle. And I would note that the respondent's skeleton suggests a different chronology, but actually if you look at page 312, it's clear that the fingerprints were taken on the 3rd of February in response to a claim for asylum.
Okay.
He has been clear from the outset of his claim, from the first interview, that he travelled through both Italy and France. And I make this point because this is not a case where there's been any attempt by the appellant to hide his travel history. There is no fraud, and there is no lack of credibility on his part in an attempt to circumvent the Dublin regulations. So even if that were relevant to any of the points that I make, for example, if a mistake of fact was made because of his conduct, it doesn't arise in this case, because you can see quite clearly from the screening record, which is the relevant part is on page 319, that when he's asked about his travel history, he says, why have you come to the United Kingdom? This is at 3.1. He says, to claim asylum. Have you ever been fingerprinted in any country? Yes, I was fingerprinted on my way to the UK, but I don't know the country. I think it was the 6th of October 2015, but I'm not sure. Actually, the Eurodac records show that it was the 7th of October 2015, so he was fairly close in respect of that. Outline your journey to the UK. He says, I left Eritrea for Sudan. I spent a week in Sudan, travelled to Libya. I then left Libya by ship to Italy on the 5th of October 2015. I spent a night in Italy, and the next day I travelled to France by train and arrived in France on the 7th of October 2015. I stayed in Calais for about 4 months, then travelled by lorry to the UK. I arrived on the 3rd of February 2016. So he's been very clear that he went to first Italy and then France. He also repeats this in his substantive asylum interview record at page 338 to 339, questions 115 to 120. So having been very transparent and open about his journey to the UK through the 2 Dublin countries, on the 20th of March 2016, he was informed by letter that the UK believed Italy to be responsible and that a decision whether to transfer him to Italy would be known within 2 months, i.e. by the 19th or 20th of May 2016. And that letter is not referenced in my speaking note, unfortunately.
Is it 345? That's the letter of the 6th of September 2016 that says Italy is going to deal with you.
No, it's not. It's
Before that's March.
326.
March.
326.
Thank you very much.
326.
So that's the letter informing.
We're just turning it up. Just give us a second. Yeah.
Informing him that a decision will be known within 2 months. Following the expiry of that time limit on the 20th of May 2016, the next thing that happens is that he was sent a letter inviting him to interview, and you find that on page 327.
326 is just a standard form letter, isn't it?
It is, yes.
It doesn't. Does it actually refer to the other country by name?
No.
No, I can't see Italy on it. So that's just a standard form letter.
It is. I apologise.
Okay.
That's a standard form letter.
Nothing turns on that letter, does it?
No, safe to say that he was informed you will know within 2 months.
Yeah, fine. But again,
Well, and it suggests that the Secretary of State was considering the application of the Dublin Regulation to his case.
That's right.
yeah. And where's the 2 months? There it is. Okay. I mean, is it always 2 months? I mean, is this what it's? Is every person in this, every claimant in this person's in the appellant's position would have got a letter in these terms, whatever country, whatever.
Yes.
Okay. All right.
Save.
Well, Mr. Payne can come back on that maybe. Okay.
So they do say, sorry, just to complete this, they do say a formal request has been made for the transfer of your claim. Don't say where to, but that a request has been made, and that a decision on our request will be known no later than 2 months. So that's where we are at that stage.
That is where we are at that stage. I think if you have actually claimed asylum and it's a take-back request, it's 2 weeks rather than 2 months.
Different letter will be sent.
But it's a different letter.
So 2 months is that in the regulation?
2 months is in the regulation.
Okay, so this is just a letter that everybody gets in this position.
Yeah, it's not specific to this
No.
claimant.
Okay. Right.
This is the Dublin process. You will know in 2 months.
Okay.
And if you want to see the Eurodac request,
No,
it was,
not a shirt. Carry on. So where do we go next?
so the letter on page 327 is the letter that is sent after the expiry of those 2 months. And this letter says, "We we have arranged an interview for you to discuss your claim for asylum, eligibility for humanitarian protection and human rights claim in the United Kingdom. Confirm that you will be attending your asylum interview. If you do not contact this office, your asylum claim may be treated as withdrawn. And it is my submission that this letter informs Appellant that his claim for asylum is being considered, examined in the United Kingdom.
Is this the whole letter on?
That's the whole letter.
When it's not.
It's not signed. It may be missing another page, but it hasn't appeared on the subject access request. And
Sorry, where does it say?
So this again is a standard form letter. I infer.
this is
But it obviously has. It's been the interpreter, the language to be interpreted, has been inserted,
my lord. Yes, if you
and the
And his note, yeah.
and the interview details. And obviously, this is a crucial letter, so far as you're concerned, is it, or a crucial letter?
well, my lord, it's a crucial letter, but we then have the substantive interview,
Yes.
which taken together indicate that the claim was in fact examined in the United Kingdom.
Yeah.
So this is telling him that the claim will be examined in the United Kingdom, and then the interview is part of the process of examination, because obviously the contents of the interview have to be reviewed by someone who then has to make a decision.
Another way of looking at it is that this letter could conceivably be seen as a procedural step. My submission is it's evidence of a decision, but I suspect the Secretary of State's position will be it's a procedural step. The substantive interview, however, is not a procedural step. It is a substantive step in terms of examination.
This is the letter that anybody who is going to have an application substantively considered in this jurisdiction would get.
That's my understanding, yes.
In these terms, inviting them for an interview. Okay. Mr. Payne may want to make submissions, but that's what it looks like to me.
And presumably your case is this letter would not be sent to someone who was going to be removed under Dublin.
You wouldn't receive one of these if you were being removed under Dublin, and the Secretary of State accepts that he should not have been interviewed if he was subject to the Dublin procedures. Again, that's in I think, a footnote in the skeleton argument. And my submission is that this was a conscious decision that was taken by an officer of the Secretary of State to invite the appellant for interview. And you can see that at page 419. This is the best that we've got in terms of evidence. This is the computer notes.
419, is that in the supplementary part?
No, it's in the core bundle.
It's in the second volume of the
Oh,
book.
I wasn't aware that.
Yes, I think we have no tabs in ours, and we do have two physical.
Oh, I've got tabs in mine.
I have no tabs
That's
in mine,
because
but I
you
reckon
probably tabbed yours.
Oh, well, I did, maybe.
419 anyway, so this is
an extract from the computer records, and if you look halfway down the page, it says interview booked for the 17th of June 2016, time 9:30, caseworker is allocated but redacted.
Okay.
An interpreter's been requested, a room has been booked, the diary's been updated, the standard events are updated, and that took place on the 31st of May.
Okay.
2016.
I'm just curious about these. I said I wouldn't do it. So the first letter that you sent us, the letter on 326, comes from the 6th floor of a building in Croydon, and the second letter comes from the 4th floor.
My lord, yes.
And they've got different references.
there are two departments in the Secretary of State's offices.
Yes.
One is the third country unit, the other is the asylum determinations unit.
Okay.
I'm not entirely sure what it's called, it depends which bit of the Home Office you're in. And it looks very much like these are coming from different offices. However, it's only relevant in my submission if the person making that decision either didn't have power in law to make it, which there is no suggestion that there was no power in law for them to invite the appellant to interview, or alternatively, if the appellant had committed fraud, where there might be an argument about it. And I can.
Okay.
I was going to leave the exercise of discretion to later, but I could deal with it now if it seems more convenient.
Now you carry on with whichever course you took. You're going to take.
If I did, I think possibly going through it in
So there's more material in the GCID notes. Representative, on page 421, the representative sent of facts with clarifications of the interview note. So there's a bit of toing and froing after the interview.
There is in one of the detention reviews, it appears that a statement of evidence form has also been sent, but I've never seen that.
Right.
And again, it's never appeared in disclosure.
No. Okay.
But just going through this in
So it doesn't end with the interview. There's further. It seems like there's further. So on page 420, copy of interview record and BRP letter given to applicant.
That's right.
Don't know what a BRP letter is, but I don't suppose it matters.
Biometric residence permit.
Oh, of course, yeah, silly me. Okay. All right. Thank you.
And then by the 1st of September 2016, which is now nearly 6 years ago, the Secretary of State had completed the examination of the claim and was ready to take a first decision. And you see that at the notes at 428. And it says at the bottom of the page, email was received on the 1st of September 2016 from blank at Sheffield Asylum Team, informing that she's just about to complete her action in relation to applicant's asylum decision, but needed to confirm at what stage this case is in TCU before making her final decision. It seems that this case has been overlooked, as the diary action was missed in May 2016 to check for a response from Italy. Case can now be enforced to Italy as no response from them to a formal request, plus a Cat 2 hit in Italy. Removal's target date is the 18th of November 2016. So this is the other department, or other office, deciding that they can ignore the consequences of the decision to examine the claim in the United Kingdom as if it had never happened and just proceed with a transfer.
Well, I'm not sure that's evident as a conscious thought process. They're just going ahead with the Dublin process, aren't they?
I think a lack of conscious thought process might have been something that runs throughout this appellant's case. But what there is evidence of is decisions, and decisions that decision makers were entitled to take. So decisions to examine the claim, decisions to invite the interview, decisions to conduct that substantive interview.
Is there any suggestion on here that this team was aware? I've slightly lost track of the dates, but has the interview already taken place?
Yes.
Yes.
And so, is there anything on here? Am I missing it? Where it says we know that she's had an interview, but let's just pretend. Let's ignore that, or is it just the third country unit saying we haven't heard from Italy, so we're just going to carry on with our process? Is there anything here that I'm missing?
No. this is
just
part of the problem.
It's
of there
silent
being
as to
no evidence.
So
for
left
this
hand and right hand. Okay.
Well, except that they do know that they've had an email from the Sheffield Asylum Team which has told them that the person in the Sheffield Asylum Team is about to complete her action in relation to the applicant's asylum decision. So somebody in the Sheffield Asylum Team is poised to sign off a decision on his asylum claim.
Yes.
Oh.
So this is these records are a computerised record.
That's right.
Who has access to it? Does everybody have access to it from all departments, or just one person from one department?
I think I'd need the help of the Secretary of State in answering that question.
Well, she's not here, but maybe Mr. Payne can answer that. But in terms of, I mean, these are pretty confusing documents to just jump into, I think.
I fully appreciate that, and what's quite unusual about the way in which this disclosure has happened is it's not the way in which I understand it would appear on the system.
Well, I wondered that. I mean, they're not all chronological, are they?
Ordinarily you have it seems to me, without any, I feel uncomfortable with this because I'm effectively giving evidence, but it seems to me that you have different screens with notes behind them, and they relate to the third country. If you look, for example, at page 411 and 412, this would normally be page 1 in disclosure. The reason I say these notes are strange is because they don't have page internal pagination, which in my experience is unusual. So this says case type, third country case, case outcome, third country action accepted. And then I would normally expect to see a set of notes behind that. And then on page 413, we have case type, asylum claim, case outcome, third country grounds, asylum refused. And again, I would normally expect to see a set of notes behind that. But in this case, they're all bundled together.
Okay. So the date of the interview was when?
The date of the interview was the 17th of June. Further submissions following the interview, I think, were sent on the 24th of June. I believe. And then this email to the third country unit was the 1st of September.
Sorry, just that last bit again. So the interview's the 17th of June. Something happened on the...
On the 24th of June,
Submissions.
there was a small set of submissions.
We got those page referenced, or do we need that?
The 343.
Okay, and I'm sorry, I didn't make a note of the 1st of September, which is, where is it that in the record?
So that's on page 428.
428, that's right, sorry.
Email received on 1st of September.
Okay. And we don't have the email? We just have that?
We just have the note that an email was received, so we don't know what it said.
So somebody in the Sheffield Asylum team had been, so by the 1st of September was poised to send out a decision, having the interview having been held on the 17th of June.
That's right. So in my submission, somebody in the asylum team had been examining the claim in the United Kingdom and was ready to move on to the next stage, which is first decision. And that's potentially relevant because of the way in which the regulation distinguishes between actions that can be taken where a state examines a claim up to the point of the first decision, but not after the first decision. And I'll deal with those when I look at the regulation. I note in passing there appear to have been 2 other occasions when he was sent letters inviting him for interview following the commencement of this litigation, but they're not relevant to this claim. As I've already referenced, in a footnote to the skeleton, the respondent states without evidence, and this is on page 43 of the bundle, the decision to invite the appellant to attend an interview concerning his asylum claim was not taken by an official working in the Secretary of State's Dublin III unit.
Sorry, where are you?
In the
43.
footnote on page 43.
Yes, I don't have, mine's not paginated, so if you could give me a paragraph number, that would be just terrific.
Paragraph 23.
Thank you.
The page of 23 at the bottom.
Underneath it.
We're not paginated.
Mine's not paginated. I'll manage. I have worth.
I don't know how they can not be.
Well, it may be the very recent updated with bundle references thing that was loose.
I had
Okay,
tried
anyway,
to
so
provide
underneath-
you with a replacement, but unfortunately that wasn't paginated.
Underneath the paragraph, the page with which the last paragraph of which is 23, there is a footnote 1. Have you got that?
Yeah, I've got the footnote.
So,
Yep.
and it goes over the page.
It's accepted that while he was subject to the Dublin III process, he should not have been invited to an interview or indeed interviewed. As such, the decision by an official who had no involvement in the ongoing Dublin III process was an error. Furthermore, it was not a decision taken for the purposes of the Dublin III process. I simply say there's no evidence to substantiate that at all. We don't know. The only thing that we do know is that a decision was taken to examine the claim. It may well be that the person who took that decision thought, well, the time limits have expired and so I'll have to get on with it. It might be that they thought, well, there's a lot of Italy litigation going on at the moment, perhaps we should just get on with it. But in the absence of evidence, this court can't realistically do very much other than to look at what's before it and say that there is a decision taken on the lawful exercise of the Secretary of State's officer's powers to examine a claim in the United Kingdom. In further support of that submission, there is no requirement within any given state for the decision on transfer and the decision on examination of a claim to be taken even by the same authority. And the authority for that proposition is MA, which is at the authorities bundle, page tab 7. And in that case, there were two different parts of the Irish administration. One was responsible, I think it's the Ministry of Justice, was responsible for determining transfer issues. And another department was responsible for considering exercise of discretion to examine claims. And the court was quite clear that paragraphs 64 to 69 on pages 238 to 9, that the decision to examine the claim doesn't need to be taken by the same national authority as that determining the responsible member state.
64 to 9.
64 to 69 on page 238.
Thank you.
Under the Dublin process, once the 2 months expired, what was the position?
In the absence of a response from Italy, it was deemed to have accepted responsibility.
And hence, could the appellant could have been removed at any point thereafter?
The appellant's position is up until the decision was taken to examine his claim in the UK, Italy was the responsible member state and the Secretary of State could have transferred him to Italy for the purpose of examining and determining his asylum claim. But the consequence of the action post that period is that the UK became the responsible member state and so no longer could transfer him.
Yes, I asked that because I'm just wondering about the footnote and the phrase ongoing Dublin III process. Your case is there wasn't an ongoing process. The Secretary of State says there was.
Well, whether or not there was, it's irrelevant on the appellant submission because the appellant relies on the letter.
I know.
Yeah.
But I'm just. Yeah. Okay. We'll see what Mr. Payne says.
I could perhaps go. Well, I will be going a little bit further than that. My position is that the Dublin regulation is exhaustive, and it sets out what happens when, and it's dictated by actions and not by decisions, effectively. So, in terms of determining who is responsible, it's either the action of an applicant for international protection through where they've travelled or whether they've applied for visas, or an action of a state that determines the responsible member state under the regulation.
So once the time has expired, the 2 months' time has expired, you say you look to the actions of the UK to determine whether the process is ongoing.
Well, the process is ongoing until, in those terms, the process is ongoing because nobody is examining the claim But at the point the claim is examined, because only one member state can examine the claim according to Article 3, that stops the Dublin process.
Okay.
But up until it's examined.
So you would say, it's just taking what the Secretary of State says at face value, that there was a Dublin process and we've looked at some stuff, and you say there was an alternative asylum process. You say, because you can only have one or the other, at the moment, after 2 months expire and the UK then embarks on its own Dublin process, sorry, its own asylum process, I got it the wrong way around, Dublin just falls by the wayside. I mean, it's that they can't then say, we're going to send you off to Italy.
No,
they're dealing with themselves.
I say that the legal effect of examining the claim in the UK under the Dublin regulation is that responsibility transferred to the UK.
Okay.
So there was no
And is it
longer power in law to
And the
transfer.
precise point is when the decision is taken to interview?
My submission would be that it is the decision that's taken.
Okay.
So sorry, I phrased it incredibly poorly, and I'm sorry about that. The mistake, there was a mistake, was to carry on beating the Dublin door at a point where, in fact, you say as a matter of law, the UK had assumed responsibility and you're only looking at a domestic
That's right.
determination.
Yes.
Okay. So there wasn't an ongoing process.
But there should not have been
There
an
should not.
ongoing
There
process.
should, well, okay.
So there may have been an ongoing process in fact, but the submission is it was
mistake.
unlawful.
Outside the law. Outside, okay. Thank you.
And I'm not going to deal with the procedural background of this appeal unless you're particularly interested in it. It's set out in the skeleton at paragraphs 11 to 15. Suffice to say, it's taken a very long time to get here. There were 3 repeat stay applications on the back of the case of Fatty, which was said by the respondent to be determinative and then now not determinative, so which I appreciate. She's at liberty to change her mind in respect of the law, but not in respect of the effect of the law. So to turn to look at Dublin and what it does and what's the purpose of it, it fundamentally governs a multiple party relationship. So it's not just between a state and an applicant, it's between member states collectively and applicants. And you can see that in the preamble, and the Dublin regulation is at tab 1 of the authorities bundle. So the title is Establishing the Criteria and Mechanisms for Determining the Member State Responsible for Examining an Application for International Protection lodged in one of the Member States by a third national or a stateless person, brackets recast. Previous versions of the Dublin regulation provided no right for an applicant to rely on them directly. And Dublin III was different in terms because it provides those rights. And it says this explicitly in various of the cases, which I will come on to. And I would like to draw your attention to recitals 4 and 5. That there should be a clear and workable method for determining the member state responsible for the examination of an asylum application. Such a method should be based on objective, fair criteria, both for the member states and for the persons concerned. It should in particular make it possible to determine rapidly the member state responsible so as to guarantee effective access to the procedures for granting international protection and not to compromise the objective of the rapid processing of applications for international protection. So the idea is it's all done quickly. Allocation is sorted out quickly based on these fair, objective, reasonable criteria that everybody is aware of. There can be no argument about them because they're set out in the regulation. And then I'd also ask you to look at recital 40, which says, since the objective of this regulation, namely the establishment of criteria and mechanisms for determining the member state responsible for examining an application for international protection lodged in one of the member states, not be sufficiently achieved by the member states, it's dealt with at union level. One of the reasons for emphasising this is because you can see it's all directed to the examination of a claim. It's not about the determination, but it's about who is examining, who is responsible for the examination. And just for Gezelbash, which is in the authorities bundle at 3, is authority for the proposition that Dublin III introduced or enhanced various rights and mechanisms guaranteeing the involvement of asylum seekers in the process for determining the member states responsible. I'm not going to turn to that because I don't think it's a particularly contentious proposition, but if you want the reference, it's paras 34 and 41 to 46 of Gazelbash at
24
34.
and 41 to 46.
That's right.
Okay, yes?
So then, what's the definition of examine a claim? That's at 2D. It's examination of an application for international protection means any examination of, or decision, or ruling concerning an application for international protection in accordance with various directives, except for procedures for determining the member state responsible in accordance with this regulation. So that means that the screening interview where the journey was considered was an interview and an examination for determining the member state responsible, because it's where did you travel, how you got any family members and that kind of thing. But the substantive interview is very clearly an examination of the application for international protection. And as I say, that's not disputed.
And the definition is a wide one because it includes any examination of, or decision or ruling about or concerning.
That's right. And the idea behind that is that when you move on to Article 3, which is in mandatory terms, there is only one state who shall examine the application.
Yeah.
And again, this is all consistent with that overriding principle that allocation of responsibility for examining the claim will be done through the Dublin Regulation, and it will be done in a fast and fair and efficient manner.
The exception is for processes for determining which state is responsible.
That's right, but under the regulation itself, that if it worked properly, which I don't think it ever has, it should only take 6 months.
But presumably the exception relates to steps taken by a member state to ask questions of the applicant along the lines of, have you claimed asylum anywhere else? Which countries have you travelled through? So that the member state can then make inquiries and see if there's a Eurodac hit.
And well, there's the Eurodac hit itself.
Yeah.
And then there's the Eurodac hit might disclose that somebody had claimed asylum in Italy in 2015. But if it's now 2017, they might have been removed from Italy for more than 3 months and then come back to the member state.
Yeah.
At which point Italy would.
So there could be factual investigations that would be necessary to establish
That's
responsibility.
right. And then also things like, have you got a spouse in another country who's claimed asylum? Are there humanitarian reasons why your children should be brought together? All of those sorts of things are designed to come out through that screening interview that we've already looked at.
Yeah.
But what that doesn't envisage is the kind of substantive investigation into why you are claiming asylum.
So in other words, the screening interview is within the exception in the definition in D.
That's right.
Yeah, okay, that's clear. Thank you.
Anything except for the screening interview that involves the substance of the claim is not, is my position. And then Article 3, as I say, is in mandatory terms. Member states shall examine any application for international protection by a third country national or a stateless person who applies on the territory of any one of them, including at the border of the transit zones. The application shall be examined by a single member state, which shall be the one which the criteria set out in Chapter 3 indicate is responsible. So, under the terms of Dublin, it's mandatory that there shall be only one member state examining the claim, and that will be determined by these responsibility criteria. And then you'll see at 3.2, just because it may be relevant in looking at Article 17, the third paragraph, where the transfer cannot be made pursuant to this paragraph to any member state designated on the basis of the criteria set out in Chapter 3, or to the first member state with which the application was lodged, the determining member state shall become the member state responsible. And I was looking at that because of what do they mean by pursuant to the paragraph? And in my submission, Article 3 sets out who is responsible. 3.1. One member state, determined by the criteria in the regulation. 3.2 provides for the circumstances where a state can't transfer, which is where there are substantial grounds for believing that there are systemic flaws in the asylum procedure in the receiving state. And then where the transfer can't be made because of those systemic flaws.
So that's sort of MSS and Belgium and all of that
those
stuff.
kinds of
Yeah.
things, yes. And then Article 4 provides the right to information, which at 4.1b is stated to include the fact that an application for international protection lodged in one member state can result in that member state becoming responsible under this regulation, even if such right responsibility is not based on those criteria. Which is what we say effectively has happened in the Appellant's case. And then what a personal interview is set out at Article 5. Article 7 refers to the hierarchy of criteria, and it sets out the exceptions to Article 3 effectively. And what I ask you to note is at Article 7.3, where Articles 8, 10 and 16 are relied on, member states shall take into consideration any available evidence regarding the presence on the territory of a member state of family members, relatives or any other family relations of the applicant, on condition that such evidence is provided before another member state accepts the request to take charge or take back. So again, these are boxed times during which things are supposed to happen. And that the previous applications for international protection of the applicant have not yet been the subject of a first decision regarding the substance. And again, the reason I say that is relevant is because if in Article 17, the drafters of the regulation had meant to say is entitled to take a first decision, or is entitled to decide an asylum claim, they would have said so, and they didn't. They used the words examine an application for international protection. And the words examining the application for international protection are used throughout the remainder of the hierarchy clauses. And then you get to Article 17, which is on page 11. And the first paragraph of that permits a state, by way of derogation from the mandatory criteria in Article 3.1, to decide to examine an application for international protection, even if such examination is not its responsibility under the criteria of this regulation. So what the state's permitted to do is to examine that application. And then the member state which decides to examine the application for international protection pursuant to this paragraph shall become the member state responsible and shall assume the obligations associated with that responsibility. Now, one of the ways that looking at the dispute between the Secretary of State and the appellant is that the Secretary of State would put the emphasis differently and say the member state which decides to examine an application for international protection pursuant to this paragraph shall become the member state responsible and shall assume the obligations associated with that responsibility, whereas the appellant says, no, if in derogation from Article 3 you have decided to examine the application, you are stuck with the consequences of that paragraph.
So sorry, is the difference between you then whether there is evidence of a decision which is expressed to be a decision under Article 17 or not?
Well, I don't think the Secretary of State quite goes that far, because it was explicitly held by the Court of Justice in Fatty that there is no requirement for there to be an express decision.
Well, so I'm not quite sure what the... well, maybe I should wait to hear from Mr. Payne.
In this case, as I've stated, the respondent accepts that the UK has in fact examined an application for international protection for which it's not responsible.
What does pursuant to this paragraph mean?
In my submission, pursuant to this paragraph means in derogation from Article 3, and that's it.
So it's the words are OTOs.
No, because there are other ways in which you could become responsible. So what this paragraph then goes on to do is explain what the responsibilities of the state become, having assumed the responsibility in derogation of the mandatory requirements of Article 3.
Well, in what way can a member state decide to examine an application for international protection?
Well, according
In
to
what other ways can it make the decision which do not make it the responsible member state?
they could be asked to under one of the hierarchy criteria.
Okay.
They could be asked to take charge of an application for humanitarian reasons under Article 16. They could be asked to take charge under Article 11 in a family procedure.
But the words pursuant to this paragraph, which pop up in the second and third paragraphs, you say are harkbacks to what's said under paragraph numbered 1. In other words, an exercise of discretion. And once you've decided as a member state in your discretion to examine an application for international protection, that Article 17 applies.
In short form, I say that the discretion is to examine the claim, it's not to accept responsibility. The consequence of deciding to examine the claim is that you have accepted responsibility.
Yep, so that's an important distinction, you say.
Yes.
Yep.
And I say that fits with the overriding objective of there being only one member state that determines the claim, that's determined by the operation of the regulation, and that's so that all of this happens quickly.
So the decision is to examine the claim, not to
transfer responsibility to yourself.
not to yeah.
The consequence of the decision is the
Not
transfer.
the consequence.
That's right.
Okay. Yes.
In terms of the breadth of discretion, this was looked at and submissions made in respect of it by the Secretary of State in the case of RSM, which is in the bundle, the authorities bundle at tab 14, and in particular paragraph 86. Which is on page 345. And you'll see there, Ms. Giovanetti submits that the wording of Article 17.1 is clear. It confers an unrestricted discretion on states. So it's an unrestricted discretion, and that's consistent with the MA authority.
That's what Ms. Giovanetti submitted, and that was accepted, was it?
That was accepted by the court, and actually if you turn to pages to page 366 and paragraphs 170 and 171, this is really about whether there's an obligation to exercise discretion or an obligation to give consideration to the exercise of discretion, not about the consequences of having exercised that discretion. 170, this is in the judgment of Lord Justice Singh.
Sorry, paragraph
170 and 171. That the effect of Article 17 of Dublin III is to preserve the discretion which a member state would otherwise have to examine an application for asylum lodged with it by a third country national. So the discretion is clearly to examine the application. Lord Justice Singh went on to say it's for this reason that the provision, like its predecessor, is rightly described as the sovereignty clause. It preserves the right of the state
And all Justice Peter Jackson agreed with these additional observations I see in paragraph 168.
That's right.
Yeah.
And then in MA, which is at tab 7 of the authorities bundle on page 237,
Two, three, seven.
237, paragraphs 55 to 61, they discuss the exercise of discretion.
So this is a decision of the Court of Justice?
This is a decision of the Court of Justice in we looked at it in respect of the department responsible for taking the decision. But paragraph 58, it's clear from the wording of Article 17.1 that the provision is optional insofar as it leaves to the discretion of each member state to decide an application for responsibility for international protection lodged with it, even if that examination is not its responsibility under the criteria. The exercise of that option is not, moreover, subject to any particular condition. So there is an unfettered discretion that is not subject to any particular condition. So it's not a discretion that has to be exercised for humanitarian reasons, or practical considerations, or because of any criteria. It's an overarching, broad, unfettered discretion. And then at paragraph 59...
Yeah, so each member state deciding its absolute discretion.
Whether to use the option conferred by Article 17 and to agree itself to examine an application for international protection for which it is not responsible under the criteria of that regulation.
I don't know whether Mr. Payne suggests that there's some magic in the words on the basis of political, humanitarian or practical considerations in paragraph 80. Do you want to say anything about that? There's some suggestion that there were no such factors here, so...
Well, we don't know what the factors were here.
Okay.
There may have been practical considerations. It could have been a mistake. But whether it was practical considerations or a mistake or anything else, what we have is a decision to examine an application. And
so your submission is you just look at what objectively happened.
That's right. And if it wasn't unlawful, it has consequences. If it was unlawful, it doesn't.
The Secretary of State exercised her discretion for reasons you don't know about.
That's right.
And the reasons don't matter because your case, she exercised it, and that's that.
And I also say that even if it was a mistake in the alternative, it doesn't matter because it was exercised. And in those circumstances, it would be valid until withdrawn. And in this case...
the whole issue of mistake, you would say, if it's going to be argued as a mistake, it can't just be raised as a footnote to a skeleton argument. It has to be, the ground has to be laid, and it hasn't.
And you would also expect an apology. We're terribly sorry that we interviewed you in the UK. It was a mistake, actually. This is what should be happening. None of that's happened in this case.
Or even an explanation.
Or an explanation. And as I say, it is one that we asked for in 2017 in the response to one of the applications for a stay.
Do you say that the examination by the substantive interview was conducted pursuant to apparent authority at least, that the discretion had been exercised, and in those circumstances it would take some acknowledgement before you could, if you like, undo the effects of it? So you would need to have, because what you said just now was that if it was a mistake, it was valid until withdrawn. And I just wanted to pick away at that a little bit. It was valid, why? Because the interview was conducted by somebody who was acting for the Secretary of State?
Because it was a lawfully conducted interview, and the decision to conduct it and the decision to examine that claim was something that the person who took that decision had the power to do.
But you do accede or accept the notion that if somebody else came along and said, oh, that ought not to have happened, it could have been undone, do you? Or do you say it's a one-way ticket and once you've done it, you're stuffed?
I say it could have been undone, provided it was notified, firstly. So an opportunity to challenge the reasons for rescinding it were given. That it was undone within the time limits prescribed by Dublin, which I believe it would have expired. I'd have to add those periods of time up, but I'm fairly certain it would have expired.
Does the fact that the invitation to interview was issued after the expiry of the 2 months have any bearing on this? I mean, supposing the letter from from floor 6, or whichever floor it was, had been sent out the next day after would that be more? I mean, might be thought to be more obviously a mistake.
I don't.
Does the fact that it's come after 2 months assist either way?
I don't think the timing of it particularly matters. It's the act. I have decided to examine your claim for asylum in the United Kingdom is an act of deciding to.
I was just wondering whether, if a contradictory letter had been sent out before the expiry of the 2 months, would it be more obviously a mistake?
I don't think so, because of the ambit of the discretion. So the Secretary of State can decide at any time, for any reason, to examine a claim in the UK for which the UK is not responsible.
And so it can do that even in the period when the request application has been the 2 month window.
At any time, for any reason, and as you'll see from FATI, there are no procedural requirements to inform an applicant of why it's doing that.
Okay.
And that's, you can imagine a scenario, for example, during COVID. We just decide to examine all the claims in the UK because we can't remove anybody because there are no flights, even though another state is responsible. That could be one reason. There could be I could come up with multiple other reasons why a Secretary of State might choose to make decisions at any given points in time. But the reality is, in this case, we don't know. We just know that one was made.
I'm just trying to work out what the real distinction is between you, because I think what is said against you is that no decision was made to look at the asylum issue in the UK. It was just a mistake that somebody interviewed him. That's their case. Your case and responses, it doesn't really work like that. If you interview somebody, that is a decision. Yeah. That's the fact of interviewing, and that is an examination, and that is everything you need, if you like, under the directive. So going back to my earlier point, you can undo that if you think you've made a wrong decision, but there are certain, you have to notify it, you have to do it in a certain amount of time, and none of that was done here.
I think that's right. And I also think if you've told somebody, we have decided to interview you in connection with the examination of your claim in the United Kingdom, you can't say that's not a decision.
Yeah.
Because otherwise what is it?
Yes, what's that decision of the House of Lords? It's only a decision when it's been communicated, but once it has been communicated, it is. I can't remember the name of it, but it'll come back to me.
It's not anisminic.
Sorry?
Not anisminic?
No. It's Anafrageva, exactly. All right, thank you.
So the remainder of Article 17 itself set out the responsibilities of the member state who's taken the decision to examine a claim for which they're not responsible. And in my submission, the failure of the UK to take those actions, which is relied on by the Secretary of State for saying, well, we didn't exercise our discretion under Article 17. In my submission, that doesn't negate the consequences for the applicant. It might mean that in the future, the UK would be potentially liable for another state taking responsibility in circumstances where they shouldn't. So, for example, if the UK refused the claim, removed the applicant, and then the applicant turned up in Germany, and the UK hadn't updated the Eurodac system with the fact that the appellant had been in the UK, Germany might have an issue. But it doesn't bite on the appellant. That's why at the outset I said this is an unusual regulation for defining those interrelationships between both states and applicants.
So in other words, there can be interstate consequences, but it doesn't necessarily follow there'll be consequences for the applicant.
That's right. And certainly not negative consequences for the applicant. If we could also look at the case of FATI, which is tab 5. You might think that FAFI is determinative of this issue. If you look on page, what happened in that case was, on page 119, the facts are set out. An Iranian national of Kurdish origin applied to the Bulgarian authorities for international protection. The authorities rejected his application without expressly deciding that Bulgaria was the member state responsible for examining the application according to the criteria set out in the Dublin Regulation, and then he challenged that decision. And the court held that Article 3 did not preclude the authorities of a member state from conducting an examination on the merits of an application where there was no express decision by those authorities that the responsibility for conducting such an examination lay with the member state. And the operative part, and really the most relevant for our purposes, is paragraphs 51 to 56 of the decision, which are at pages 156 and 157. And again, this is a decision.
Would you like us to read these?
Yes, please.
Do you want to sit down for a moment? So 51 to 56. Yep.
Yes.
I started looking at paragraph 51 in the Advocate General's opinion.
I think it's on
It's all right, I found it now.
156, I think we should be.
Several skips behind the bead. I haven't read the whole of this decision. Was there any evidence of the reasons why Bulgaria had decided to examine the asylum claim?
Not as far as I'm aware. I think they decided it was unfounded, so they'd be able to remove him quickly.
Clearly, the points raised in the last sentence of paragraph 53 have any impact on your case? In other words, there the court sets out its understanding of the reason for this power, which it doesn't look as though includes any possible reasons for the decision in this case.
I think when you read paragraph 53 of this case in conjunction with the paragraphs that I referred you to in MA,
Okay.
which is at tab 7, and RSM and the Secretary of State's own understanding, it's clear that although that might have been the underlying intention of the drafters, what the effect is that there is no limitation on the discretion.
Does Halaf give us any assistance?
I have looked at it previously, and from memory, it just says that. It doesn't go any further. Does that make sense?
It's what's said in the last sentence.
It's just
Okay.
says what's
Thank
in
you.
paragraph 53. There's another case as well that says the same thing, but it's
So it's one of
like
those
with many
formulae.
of the CJEU decisions, they just adopt the same sentence over and over again.
Ms. Hooper, before you leave it, paragraph 56, we therefore take from this that a member state can conduct an examination on the merits of an application for international protection where there's no express decision by that authority. In other words, they can just do it as a matter of discretion. There's no formality attached to it. My question to you is this: did the full court disagree with the AG, who said at paragraph 30 of, I don't know if it's a he or a she, I'm sorry, of their decision, that they were inclined to the view, on the basis of foregoing considerations, that the use of the sovereignty clause requires that the member state intending to rely on it must adopt a formal decision to that effect. Do we knit those? So is the latter disapproved?
They explicitly disagree with that. And so what's very clear from Flaherty, therefore, is that there is no requirement for an express decision to adopt responsibility. There's no requirement for an express decision to transfer responsibility. That the state's discretion is to examine the claim. And it's not to make a decision on the claim. And I say that at this point because the Secretary of State, in her written submissions to the court in that case, which are in the core bundle at page 362, and in her submissions to this court, appears to seek to distinguish between the ability of the state to examine the claim and the ability of the state to decide the claim.
Decide to examine.
No, to decide the claim.
Okay, I thought there was also a further sub-hair split on decide to examine as well as decide the claim.
I think there probably is. It's a very thin hair.
Well, sometimes we have to deal with those things.
Splitting hairs.
It's an already split hair that's being split even thinner.
Sorry, I was on the
Enough hair jokes, Mr.
Decide to examine and decide.
Is there
So there
something
are
particularly you want us to
three
look
possible-
at in the UK submissions?
Yeah, just hang on a sec. I think, can we just note those split hairs down? The possible split hairs. Is what we're talking about.
A decision to examine, an examination, and a decision on the claim. Is that the three-way split?
So a decision to examine the claim,
Yeah.
the examination of the claim, and the decision resulting from the examination of the claim.
Okay. Yeah.
I think those are the three.
And what are those three decisions doing? What is said to turn on those decisions?
Whether or not responsibility transferred to the UK.
So R says, I hope I'm not misstating this, and I will no doubt be told if I am, that the fact that there's an examination does not equate either to a decision to examine or a decision on the claim. And those things are the things that the directive looks at. So if you happen to examine a person, that doesn't get you into Article 17 or indeed or derogate from Article 3. I think that's their case, isn't it? And you say that's wrong because the moment you've examined, you have decided, you've made the relevant decision.
That's right, but also on the face of it, that's what the directive says.
Yeah, no, I've got all that. Yeah.
It's a regulation.
It's a regulation.
But you say 56 deals with 56 of Flaherty deals with that.
Yes.
Paragraph 56 knocks all that on the head
Yes.
because it says
Yeah.
what it
Make a
says.
decision to examine.
What it says.
Yes.
Okay.
In fact, I say explicitly A's case is that Flaherty is determinative.
Yes.
No expression decision required, no form of that decision prescribed. We did decide to examine the asylum claim in the UK with consequence responsibility transfers, and
okay.
that's it. There's some suggestion by the respondent and adopted by the judge below that evidence of intention.
Do we need to go to the UK submissions? Which is what I've got open, UK observations.
In the UK observations, you may want to note paragraph 24 on page 370.
Sorry, I missed that again.
Paragraph 24 on page 370. Probably starting at paragraph 23 is not necessary that each applicant should receive a notification expressly stating that a member state has decided to examine its requests. It describes this as being to introduce an unnecessary formalistic stage in the examination procedure. And then paragraph 24. Paragraph 27 again repeats that requiring a decision to be made that you are the responsible member state would introduce an unnecessary formalistic interim stage in the determination procedure. And then paragraphs 31 to 33 you'll see reference at 32 in particular to this idea that a procedural step is different from a substantive step. And the Secretary of State's submission in that case was the fact that a further procedural step had been initiated. For example, that a member state authority had set a date for or even conducted an interview in order to make a preliminary assessment on the substance of the claim does not indicate that a member state has assumed responsibility for the examination of the claim. So that was a submission of the Secretary of State to the Court of Justice, but it's not one that was adopted by the court. So whilst the Secretary of State in Fatty was willing to accept that failing to issue a decision saying we're taking responsibility for the claim did not invalidate the decision on the claim,
does the court in Fatty expressly touch on any of those points?
Save for accepting that there is no requirement for there to be an interim indication that you're accepting responsibility, no. But what it does do is use examination of the claim as opposed to decision throughout the judgment.
It doesn't express. I'm sorry.
Oh, sorry. No,
it doesn't expressly deal with these submissions.
It doesn't deal with 32, which is this further procedural step initiated. No.
But that appears to rely on a dichotomy between examining the claim and assuming responsibility. And as I understand your submission is that the court in Fatty did not adopt that dichotomy because, as far as the court was concerned, examination entails an assumption of responsibility.
That's right. And examination entails assumption of responsibility in derogation from Article 3. And then finally, in respect of this, I thought through the consequences of the respondent's argument being right. And one of those consequences could be that a member state could, in the exercise of its discretion, decide to examine an application for international protection that it wasn't responsible for, and then prior to deciding that the person should benefit from international protection and be recognised as a refugee, change its mind and send them away. And it could choose to only send away refugees and to not keep people and to not send away people who it decided had unfounded claims. And that would be wholly inconsistent with the principles of the Dublin Regulation. So in my submission, not only is the appellant's grounds clear and consistent with the principles already determined by the Court of Justice in February, but also real practical considerations why that should be right. And realistically, this is a situation that just shouldn't arise. If on the Secretary of State's case it was a mistake, as long as she doesn't make any more mistakes, then one would hope that any consequences of this one would not be visited on her again.
Yeah.
In terms of relying on the thing that I think was troubling your lordship on what's the consequence of a subsequent event, I think Mengestea is also authority for the proposition that the appellant can rely on a subsequent event even if the other member state is willing to take charge. And in Mengestea it was about the expiry of a time limit. So again, a mistake made by the sending state because it failed to do something within a certain time limit the other state was willing to accept return of the applicant, but because the time limits had expired by mistake,
Yes.
responsibility transferred
Yes.
To whom
to
was
the
retained.
sending member state rather than the receiving.
And
Just sorry, I'm forgiving. Can you just say that
that's
again?
not quite, I haven't quite caught up with that
Yeah,
point.
no, we're both. Just say that again. And just show us.
Maybe
why.
I'll go through it more slowly. With
Yes.
maybe with
It's
the
only for my
authority.
benefit. I'm sure.
It's your fault.
For my, the convoy moves at the pace of the slowest ship. As an old judge said to me when I was in your position a long time ago. Carry on. That's me, by the way. Not milady.
I thought it was me.
No, anyway, anyway, never mind all that. Please will you help me with your submission?
In Mengestea, which is in the bundle at tab 6. You can have a look at it.
Tab 6. Oh yeah.
I'll make sure I've got that transfer the right way round as well. Germany requested that Italy take charge of the applicant.
We probably don't need to go through the facts. If you could just find the paragraph which sets out the proposition or supports the proposition you've just put forward. Is it marked?
No.
Nothing marked.
Paragraphs 54
In the judgment.
in the judgment, which is page 217.
Yeah.
So 54 to 56.
Yeah. Okay. And that's recital 5. Okay, that's the
My lord,
Point
if you
behind
just bear
it.
with me one moment. My slowness at this point.
I'm going to ask Ms. Hooper, just when everybody's sort of ready, can you just go over the point again, because I'm not sure I've quite got there.
I will, yes, thank you. So on looking at what was held in that case on page 168 in the head note.
Yeah.
This was about the right to a remedy where things had gone wrong.
Yeah.
Because procedural steps had gone wrong, and in this case, a breach of time limits. And what the court accepted was that there was a right to a remedy for a procedural error, procedural step, which is once the time limits expire, you're no longer transferable.
So, what, in other words, that the applicant could enforce the time limits in Dublin?
That's right.
Yeah.
And so the reason for the expiry of time limits is the state's failure to comply with them.
So in this case, because Germany hadn't acted within the applicable time limit, it was fixed with responsibility for just examining the applicant's asylum claim.
That's right.
And he could fix Germany with that responsibility under the right to remedy provisions.
Yes. Even though, under the remainder of the regulation, Italy was responsible for his life. So, even if you were to accept this is a procedural issue and not a substantive issue, Mengestea says that's irrelevant. And at 56, the UK it's noted explicitly that the UK tried to argue that the procedural nature of the rule meant that it couldn't be relied on in the context of the remedy, and that was rejected by the court.
Sorry, so even if we were to accept this as a procedural, not a substantive issue, but there's a case that you're citing to us that says that it doesn't matter.
Mengestab, the one that we've just looked at.
That's what we're in, isn't it?
Yes, it's the one we're in at tab 6. But if the consequence of the procedural step is set out in the regulation, then that consequence has effect for the applicant.
At which he can enforce under
That's
his
right.
right to a remedy.
And how does that play in here? That because was there something to do with the time limits having been exceeded here?
The time limits only come into play if you start looking at whether or not a decision could have been rescinded and when it could have been rescinded and what the consequences of that could have been. Because you have to make, if the UK had become the responsible member state, which we say they had by the decision to examine the claim, they would then have to make an application to Italy to take charge of that claim, which they were not in fact responsible for under Dublin. And then I think the time limits for making a take charge request are within a certain period of making the claim for asylum in the first place, which would have been February 2016.
Well, when I think what Milady's asking, I'd like to know too, is how does that work in practice in this case?
Does it make a difference here? Not quite sure where this fits in, this line.
All right.
So is your point that even if the decision to examine the claim or the steps taken to examine the claim in the UK are procedural matters, they can nevertheless be relied on by the applicant as showing that there's been an exercise of the sovereignty clause and that the UK is therefore the responsible state?
That's right.
Okay.
So
Milady understands it, but I don't. So just help.
it matters not.
Remember the slowest ship point.
It matters not whether it is a procedural or substantive step in examining the claim if it falls under the definition of examination of the claim.
Okay.
So is that an interpretive point? So that goes back to the language of the regulation, does it? That it just talks about examining the claim. So it doesn't really matter what the character of the examination is. Although you do accept there are some sorts of examinations, like a screening interview, that wouldn't count for regulation purposes.
It expressly doesn't count.
Expressly doesn't count.
Got it, okay.
Because isn't the screening, I was just looking at Article 5. It's in Article 5 of the regulation, which is headed personal interviews. Isn't that the equivalent of the screening interview?
That is the screening interview, it's not the asylum
Yes,
interview.
exactly, that's my point. So the regulation deals expressly with the screening interview in Article 5, and it requires the member state to carry out a screening interview, and that's not part of the process of examination.
That's right.
Examination is something different.
And effectively the examination of the claim is done under the Procedures Directive rather than the Dublin regulation.
Right.
I think in respect of the substantive issue, those are
That's your case.
that is our case.
Okay. So where do you want to go to next? Academic?
Yes.
Is it academic? And if so, so what?
So in the appellant submission, it's not academic because the issue remains live between the parties and the damages claim.
Right, this is what I'm really keen to understand.
Because of what was happening around the time of this claim, the damages claim got separated from the substantive
Yes.
removal claim. And it had to be brought at the same time in the same proceedings because of the case of BA Nigeria in this court.
Okay. Had to be brought in the, no, just also had to be brought in the same proceedings, because of which case?
BA Nigeria.
Okay. Right. Yes. Yes.
You may disagree with, but
Yep.
Okay.
Yeah, so
Okay. And
which suggests that it might be an abusive process not to link your unlawful detention claim with a removals claim if you're.
So one of the three decisions that were challenged in the application for judicial review were the third country certificate, the removal directions to Italy, and the detention of the applicant.
That's right.
Yeah.
The detention was challenged on several grounds, one
Yeah.
of which was what's known as the Hamati ground, which is the process of detaining Dublin applicants at all. And
Was the detention challenged on that ground?
It was
Can you just give me a reference to that, please?
in the original grounds for judicial review.
They were amended at some point, weren't they?
They were, but this ground remained consistent throughout.
Okay.
It has not changed.
So I think tab 10 is the. Oh, wait a minute. So tab 11 is the original grounds for judicial review, I think.
and the page number for those of you that are untabbed.
Oh, sorry, page 92. Right.
Those
So,
grounds are on page 104,
yeah.
paragraphs 38 to 41. And then over the page on page 47, again there is reference to the detention being unlawful for being in breach of policy on the grounds that no reasonable Secretary of State could have concluded that removal was lawful or could take place within a reasonable period of time.
Sorry, just you'll just slow down a bit. Change the photos. Yeah, so you say in paragraph 38, the detention was not lawful because he couldn't be removed under Dublin III effectively. So that's the Farty ground.
Yep.
I don't see reference to Hamati. Maybe I missed
Well, it hadn't been decided at that
No,
point.
but the grounds, the sort of the line of Hamati, which was that there weren't sufficient criteria.
Detention in breach of Article 28,
So Article
Dublin
28,
3 is
yeah.
paragraph
Sorry,
42.
I'm so sorry, I was interrupted.
42. Paragraph
Paragraph
42 of the claim. Of this.
Am I correct to look at paragraph 42 of the claim?
Yeah.
Subheading, detention in breach of Article 28, Dublin 3.
Thank you.
Yeah, so in other words, you shouldn't detain solely for the purposes of removal, and you can detain if there's a significant risk of absconding, and you've got to have the further elaboration in Marty's, you've got to have criteria set out in domestic law which tell you what the criteria for detention are.
That's right. And in this case, he wasn't in fact detained because of risk of absconding. He was detained solely on the grounds that removal was imminent.
Yeah.
And that
Okay, so
is seen at the document at tab 46, page 347 to 349. 347 to... I'm conscious that I'm looking down, so I'm
right.
probably not carrying.
347, 349.
347 to 349.
That's the notice.
Notice to detainee and reasons for detention. The removal from the UK is imminent. You've previously failed or refused to leave the UK when required to do so.
Right.
And then on the 28th of October, when that detention was reviewed, you'll see 350. Your removal from the UK is imminent. You have not produced satisfactory evidence of your identity, nationality or lawful basis to be in the UK. You'll also see that the response to the Rule 35 report, which said that he shouldn't be detained, maintained detention on the basis that removal was imminent.
Okay.
So those are various features of this case where the imminence of removal bears on decisions to detain and behaviour of the Secretary of State in relation to that detention. The Secretary of State accepts that the entire period of detention was unlawful, as she's required to do because of penalty, but doesn't accept the grounds. And that has two consequences for the appellant. The first is in relation to...
Just take this slowly, would you?
Yeah.
Because this, I think, is quite important. Two consequences for you, your client.
One, it impacts on what he is able to argue in respect of quantum.
In due course.
That's right, and that quantum decision is likely to be determined either by the Queen's Bench Division or by the County
Central
Court.
London County Court, I think, is a bit more likely, isn't it?
I think it's probably the County Court. And in reality, if this claim was withdrawn in this court or conceded in this court without being determined, he could not rely on any of those arguments in the lower courts because they've been determined against him by the administrative court. So he would be stuck.
So you can't rely on the Fati arguments, you can only rely on the Hameti arguments.
That's right.
Did the administrative
difference
court
is
even deal with the Hamati argument?
No, because it was all stayed.
Right.
It was thought for cost reasons at that point that it was better for them to be
So
stayed.
explain to me, if you would, what are what is likely to be the substantive damages consequences? I mean, will there be significant? I mean, what sort of damages are we talking about here? How does it differ, depending on? So if it was just the Hamati ground, what would, as opposed to all the grounds?
So at the moment, if it was just the Hamati ground, there would be an award for basic damages,
Okay.
plus possibly aggravated damages arising from the fact that he had a psychotic breakdown in detention.
Yeah.
And it looks like there were some medical requirements not complied with, but it's not clear yet because we haven't had full disclosure on the detention claim.
Okay.
I'm of the view that the conduct of the Secretary of State, if I'm right in relation to the Article 17 argument, the conduct of the Secretary of State in detention and in detaining the claimant and in the conduct of this litigation is relevant to aggravated damages.
So
Do you mean aggravated or exemplary?
At least aggravated. I'm hesitant to say it would go as high as exemplary,
Right.
but reserve his position on that.
Okay.
Okay.
There are.
So what are the two what's the spread? And what's the bracket here? I mean, just so we have it. I mean, is that not a legitimate question? What's in it? I mean, what turns on this financially, potentially?
From the principles of aggravated damages, I can say it's unlikely to be less than £1,000. It could be between 1,000 and 10.
So,
Thousand, not 1,010, but £1,010,000.
say that again.
So on aggravated damages, I would expect an award to increase between £1,000
Yes.
up to probably around £10,000.
But above and beyond, because what you're saying is you think you've got a ground for aggravated damages anyway because of the psychotic breakdown and the failure of medical supervision. You're adding in there a component based on the Secretary of State's conduct, which I have to say I haven't quite grasped yet, so you need to explain that to me. And you would quantify that, taken separately, as something between £1,000 and £10,000.
I would say the global figure of aggravated is between 1 and 10.
Including the psychotic breakdown.
Including the breakdown, which you say you've already got in the mix.
That's right.
And what's the conduct aspect?
Why is the conduct different? Because in both cases, the Secretary of State has breached EU law. In one case, the Hamati ground because she didn't have criteria in domestic law and because she detained solely because of Dublin. And in respect of the Fati ground, because the United Kingdom was the member state responsible. I'm just not really understanding why that has any bearing on the amount of damages to which the appellant is entitled for a relatively short period of detention.
So the highest I think I can put it is a lack of care and attention paid to his case from the outset, which could amount to a high-handed and blinkered manner about the consequences of having taken the decision to examine his claim in the UK. The conduct of the litigation include failures to respond to pre-action letters and repeated, I think the stay application.
But all of that
come into this.
only gets you up to £10,000 maximum.
Yes.
Well, I think you'd have to. It's much less than that because 10,000 is your top line figure on a good day in the Central London County Court for aggravated damages all in.
Yes, I agree with that.
And we're talking about the conduct element of it only.
That's right.
But you're not at the moment submitting that this conduct element would entitle you to exemplary damages, or were you saying it might?
I'm
clear
not.
about that.
I'm not putting that forward at this point, but
I've just noted that you're reserving the position.
reserve my position on it because I haven't seen the disclosure, if there is any further disclosure. But potentially,
Well, I suppose that's fair enough. You haven't seen full disclosure.
it potentially impacts on any award for initial shock. On the basis that he'd been told his claim was being dealt with in the UK, he then gets detained
Yeah.
for the purpose of transfer. So there's he would have an expectation by that point that his claim was being dealt with in the UK, and so for him it's different to an ordinary Dublin.
Okay.
Yeah.
So is there any other basis from which you challenge the assertion that it's an academic claim?
The second reason it's not academic for this appellant is because the consequence of the joined litigation and the costs orders is that he will be unable to recover.
Yeah. Yes, the conjoined litigation, because the conjoined certificate.
That's
One
right.
statutory charge.
One certificate, one
Yes.
statutory charge. And this, I think this is complicated. The authorities that you have produced by the respondent make it clear that it would not have been possible, I think, for the appellant to have sought to overturn the costs order made in the court below on the basis that he thought he was right without winning the appeal. Because that's what the authorities say.
Yeah.
If the concession is on a completely different basis, you're not entitled to your costs.
Yeah. So, though, in fact, are you saying the cases Mr. Payne's produced support your argument for it not being an academic appeal?
There's no authority directly on point that I can find. There is obiter comment, which is both unhelpful and helpful. which
That
might
is
be
usually
unhelpful
the way
for
with
the
obiter
court,
comments.
but-
That's usually the way with obiter comments.
So as I understand it, one of the authorities you referred us to yesterday in your helpful supplementary skeleton was Ainsbury and Millington, where there's an obiter comment by Lord Bridge that it may be proper to proceed with an appeal which is otherwise academic if it can affect the position of the parties in relation to costs. So is that one of your points?
That is one of my points.
Okay.
But it doesn't affect. Can I just reel back? The reason you want to argue this, the costs reason for arguing this appeal, is that by winning this appeal, you hope to reverse Mr. Justice Murray's costs order, which was no order as to costs.
That's right.
And the way that no order as to costs settle is that if your client were to recover some damages, there's obviously an amount owing to the legal aid agency, or whatever they're called now, Legal Services Commission, so that would be recouped. Whereas if you had a costs order in your favour at this level, which would then turn the costs all the way down, the legal aid agency would recover its costs from another limb of state, namely the government,
That's right.
and your client would recover some damages.
Yes.
But your client's in no different position from anybody else who gets legal aid, because legal aid really is just a form of lending, isn't it? But who ends up having some of the ultimate benefit of the litigation recouped in order to pay a costs order. It's the way legal aid works.
That's right if there is no order for costs. There is an argument to say that it's in the interests of the legal aid agency, actually a requirement for counsel representing under a certificate to try and seek recoupment of the legal aid agency's costs.
Yeah.
You mean recovery rather than
Recovery, yeah.
Yeah.
The legal aid agency, as far as I'm aware, is unlikely to say, I don't know if it's been asked in this case, go for a full appeal, incur the costs of a full appeal, so that we might stand a chance of getting our costs back against the government.
the legal aid agency are very aware of the issues
Today.
in the case. So
Because they withdrew the certificate
They
from it,
withdrew
didn't they?
the
So you've had to
certificate.
give an advice and so on and explain what's happening.
and it went to an independent funding adjudication, so that they're not unaware of what's going on in terms of funding the appeal. And similarly, the reason that I put in the documents in, because I'm aware that we were also under a duty to inform the court.
Yeah.
So although there wasn't a formal respondent's notice, it wasn't a skeleton argument, and then we raised it again in response to directions from Lord Justice Lewis in December. One of the COVID years, I think it was 2020. So we.
So the LLA have got an interest in pursuing the appeal if they think that it might lead to a costs award in your clients, a reversal of the costs order that was made below.
I think that's right. I think the
Because they'd recover their costs of the first instance hearing from the Secretary of State.
yes.
Okay.
No, it's no order as to costs. So the legal aid agency hasn't recovered its costs at all of the.
No, that's my point. If the appeal succeeds, the LAA will recover its costs from the Secretary of State.
But the point you're making is that would leave your client with some damages.
Yes. And I rely on the case of H in Northamptonshire, which is this sort of issue. If I set out the background, this sort of issue arose in the family court.
Yeah, well, I was, of course, I'm familiar with this. It's arisen for many years in the family courts because legal aid certificates are granted for family proceedings that include children and money issues.
And then the costs of those proceedings outweigh any damages in the human rights claim that's brought in a different court.
Yeah.
And the consequence in those cases was that an action was brought against the legal aid agency.
Yeah.
To require them to change the terms of the statutory scheme, statutory charge, and way in which that operated, which was done in respect of family cases, but doesn't extend to immigration.
Sorry, which
cases.
Tab 15.
tab of the failing to keep up. Thank you.
So the underlying point is that this court, if it were to decide that the appeal is academic, has a discretion to hear it. My primary submission is it's not academic because there remain issues between the parties, not least settlement of or trial of any damages issues, but also in terms of costs. And from the way that I hope I've made clear, there's no prospect of recovering the costs unless you pursue the appeal. There's no prospect of arguing the issues on the damages claims so as to try and avoid the imposition of a statutory charge in the damages proceedings. And so, having looked at it in the round, the only thing that I submit you can conclude is that there remains an issue between the parties. And if you look at, in particular, Salem and the other cases on an appeal being academic, what had happened in those cases is that they'd all agreed all of the issues, including the orders as to costs by the time of the hearing, and that's not what's happened in this case. So the reason for reliance on H and Northamptonshire County Council, and a reason which in my submission should form part of your decision on this, is that the
Is it point 2 in the head note?
It's the obiter comments at 122, which are right at the end, which is that it's whether or not, in the context of human rights act claims brought by children and parents during the currency of pending care proceedings, is whether it's just, equitable, or reasonable that damages awarded to a child or to a parent as a result of the breaches of his or her convention rights should be recouped by another organ of the state, which is what will happen in this case if the appeal is deemed academic and the cost order is not overturned.
But how does that help us? Because this isn't a legal principle which was invoked in order to affect the decision that Mr. Justice made in that case. He's just saying, and by the way, isn't he?
This was a claim about recoupment.
Yeah.
And I accept that this appeal is not. The reason I say it's relevant to your lordships is the exercise of discretion in deciding whether to hear and determine an appeal that's academic if you decided to find that it was academic.
Yeah. Mr. Justice is an extremely experienced family judge. This is an obiter comment at first instance. Have you got any other authority to support you?
My lord, there is no is the answer to that. No, I couldn't find anything
there are plenty
that
of,
was on point.
I mean, there's a lot of dicta, including, I can think of something I've said it, in which the fact that it's one organ of the state versus the other organ of the state should not deter a court from making decisions about costs, applying principles.
My lord, I agree, and that's part of the reason why we say this is not academic, because the only basis on which we could ask this court to make a decision on costs is by proceeding with the appeal.
But that doesn't make it unacademic. I mean, the academicness goes to the substance. And you've made your points on damages, and we'll think about that, obviously. But it might be said that there really isn't much in this and left, because you have got, you've got where you've got to. So it is just a costs issue, which you can't avoid.
There's not much more I can say to that other than.
I mean, the statutory charge is a blunt instrument.
It is.
But as I understand your submissions, what you are saying is that even if the appeal is academic, and even taking into account the provisions about the statutory charge, which you can do nothing about, the dictum in Ainsbury suggests that a court may hear an appeal even if it is academic, if it can affect the parties' positions in relation to costs.
Yes, and I think that's right as well in respect of private cases where there's an issue as to costs.
Yes, well, I mean, that's the point Lord Bridge was making, because in that case, both parties were legally aided, so that's why the comment's obiter. Because the fact that both parties were legally aided meant that there was absolutely no justification for hearing the appeal, because it wouldn't affect them, either of them.
That's right.
Whereas what you're saying here is, yes, you're legally aided, but if the academic appeal is if this court decides to decide the academic appeal and decides it in your favour, you would then get the costs of the proceedings below.
That's right, and also it's notable that in those other cases there were no other financial issues.
Yeah, I mean, really, it's what's meant by academic, isn't it?
It is.
Is an appeal academic if it's clear who's going to win and who's going to lose on the appeal dismissed, appeal allowed basis? Or does academic mean it's academic as to any consequences?
Yes.
If it's only academic, if the outcome, the consequences are the same whatever the outcome, that's when it's academic. But if the consequences differ or vary, then it's not academic. That's your point.
It is.
In fact, you put it much better than I did.
I think it's a lease. I'm not very good with the Latin, but I think it's described as where there's an argument between.
Well, if there is a lease about costs, you say, if about nothing else.
Yes.
Okay.
And we have tried settlement over a period of time, and we failed.
Yes. That's interesting.
Okay. Is that it?
Do you want to address us on the cases that were submitted by the respondent that seem to be very much on this point, or do you want to deal with those in reply?
Or I can deal with Araso. So
That's Lord Justice Singh, is it?
No, Raso's the Davis one, Michael Davis.
Have you got anything to say on Lord Justice Singh?
Yeah, what
I'd
about
say Lord Justice.
that court? That was quite a powerful court, and they seem to have this particular problem very much in view.
Okay, let's get it up. I think we'd like to hear you on both cases, actually.
Justice
So why do you start with ERASO? Because that's really rather following on, isn't it, from ZN?
What?
By the way, they're both powerful courts.
Well, ERASO is just is an obiter comment.
Sorry, ERASO is an obiter comment.
It's an obiter comment.
Yeah,
Paragraph
okay.
69, where
Yeah.
what's relevant is that I have concluded that GA is not entitled to any damages for wrongful detention. So the point of the practical effect of the impact on the legal aid regime falls away. My present view is very much to doubt if it could be justified in principle to mould an order as to costs away from what is otherwise appropriate simply to counter the effects of the legal aid regime. I don't think I'm particularly challenging either.
No, that's really,
say.
that's sort of what I was alluding to earlier about different orders of the state. But so what do you say about, you're going to come on to ZN, which I think we think is more it's more specific. And this is Lord Justice Singh.
Again, these are costs having consented out of claims, which is not. They're costs having consented out a claim and then arguing about what the costs
So
are.
this is an M. Croydon type of case, is it?
That was it, the attempt to argue it was that it was an M. Croydon type of case, and the problem was, as with this case, that the reasons for the claim being consented out, and for there being a consent order in those cases, was different to that pleaded.
Yeah. So what had happened was there were consent orders providing presumably for the appeals to be withdrawn, and then there was a dispute about the cost of the appeal, and that's what the court was concerned with.
That's right, and the consent orders made provision for costs to be dealt with.
Because what I was wondering was if as you've said, there have been negotiations, why wasn't there a consent order and then the parties just asking for written submissions on costs to be considered?
Because I'm aware of what these authorities say, which are that I can't seek my costs in relation to something where there is a consent order agreeing to dispose of the appeal on a different basis to that pleaded.
You were stuck.
Basically stuck.
Oh,
But
I
it might be
see.
said, do we start from the position, you say that there's still a live issue, and we'll think about that, but if we come to the conclusion that there really isn't a live issue, or not one that it's proportionate to argue, save us to costs, but on the legal side, do we get to the position that actually it's as if there was a consent order, because all the substance has fallen away, for one reason or another, and all you're left with then is costs, then we're banging this territory, aren't we?
Yes.
Because it might be said that you've manufactured, I mean, you're trying to distinguish this case from ZN, might be said by refusing to put in a consent order and withdraw your appeal because all the substantive issues have actually fallen away.
If you're not with me in respect of the detention claim, which has not been compromised.
Well, the only outstanding thing on the detention claim, as I understand it, is this point about aggravated damages, if you're right on the substance here. Yeah?
It's most likely yes, but as it hasn't been determined.
No, but I think there were some other parallels in here that the way you deal with these typically is if there's an outstanding damages claim, because that happens quite often in the admin court. You have the damages, the legal issue is compromised one way or another, but the damages claim goes off to the Central London County Court typically, doesn't it?
It does, but and if
there's a consent order to that
But
effect.
was ZN just a certification case? Was there a detention claim in ZN? And I did look at it quickly.
Mr.
I
President.
only read it rather quickly, but I can't remember. But the fact pattern we're dealing with here isn't a particularly unusual one, is it? Where you have a concession for one reason or another in the JR by the Secretary of State, and the damages claim goes off to the county court, and that's dealt with by consent in the admin court.
that's right. There are multiple reasons why you might take a different approach. So, for example, if your view was that the appeal would fail in the Court of Appeal, or was not very likely to succeed, or whatever view you took of it, you might decide to withdraw for costs reasons at that point.
Understood.
If you took a different view as to the merits, because of the consequences on the other claim, you may not. But it was not an easy It's not an easy
Right.
No,
But,
understood.
but I
situation
suppose
between
that
those
another
opinions.
difference is that in the administrative court, the lawfulness of the detention was not, the unlawfulness of the detention was not conceded. So by the time Mr. Justice Murray heard the claim in the administrative court, had the detention claim been stayed, or what was the position?
It had been stayed.
Right.
And the detention claim itself was not, in fact, conceded formally, I think, until the 22nd of May by way of letter. That's of this year.
But you'd asked for extra time. I'm sure, I know you're right, because I've flagged that particular letter, but we've had about 6 months worth of talking about it, haven't we, before that, because Hamati was the end of last year, wasn't it?
Martin was Supreme Court was
we've had lots of
2019.
time.
Okay, all right.
Nearly a year of talking about it.
Okay. Right. Anything else you want to say on the cost?
No, those are my suggestions.
Anything else?
Not okay.
Thank you very much, Mr. Hooper. Yes, now Mr. Payne.
Well, just because we've got these issues in the forefront of our mind, can I just deal with the academic ones just quickly? So
Yes.
We've got the cases sort of open in front of us. And just dealing with ZN and Araso. ZN and Araso, and the fact there are, I mean, I could have put in many, many more cases. I just didn't think you'd want to read them all. But what happens routinely in Dublin cases is you get a challenge to a certificate. Challenge takes time to determine. Most commonly, human rights considerations develop or arise. And the certificate, in other words, the transfer decision, is withdrawn. And I think there's probably a very good reason why my learned friend hasn't been able to identify a case in those circumstances. In other words, purely academic, because the decision under challenge has been withdrawn, where a court of appeal goes on to consider that, save potentially where there's an issue of wider importance. Now,
Do the typical cases you've talked about include an element of detention?
yeah, absolutely.
And a detention which is said to be unlawful for a variety of reasons?
Absolutely, and there is always, and I make no disrespect to my own friend, but there's always a sort of nearly always anyhow, a wide array of allegations as to the reasons why why detention is unlawful. But once detention is accepted as being unlawful, that certainly in my experience, I haven't yet come across an argument where the fact that it might be unlawful for 2 or 3 different EU law reasons can have any impact at all on detention. And in fact, if you look at on quantum, and if you look at Hamati says completely the opposite, and I'll take you to that. But just focusing on these cases, because there was sort of some suggestion that I think that the fact that these were dealt with by consent, or certainly ZN was dealt with by consent, might have some sort of relevance. With respect to it doesn't, because in terms of the decision under challenge, that can readily be dealt with by consent, because that decision is no longer in force. So what this case and this appeal is all about is arguing about whether a decision that's been withdrawn effectively was in fact academic. So it's no different from any of these cases. In
Was
these
right
cases,
or wrong, that's what we're arguing about, whether
Yeah.
a decision that has now been withdrawn was in its time right or wrong.
absolutely. So it's precisely the same situations in the sense that these claimants or these appellants could always have tried to maintain some sort of argument in relation to whether a decision that was withdrawn was in fact unlawful at the time it was taken. The simple point we would say, certainly in terms of costs in this case, is that, and I don't think this is challenged by my learned friend, the decision was withdrawn for reasons totally unrelated to this case. I mean, in short, because of the revocation of Dublin III in terms of how it applies to the United Kingdom. So through this case, or through this aspect of the case, the claimant hasn't achieved any success. And therefore there is no reason we would say, for any costs ordered to be made in favour of the appellant.
Isn't that partly a quirk of timing, though, because of all the delays that there have been and all the stays and so on?
Well,
Because
well, yes,
we're going back to events that happened in 2016.
my lady, yes, but I mean, with respect to how is that relevant? I mean, the key point, and I think the point that's made is that the reason the claim has become academic is due to supervening events which are unrelated to the merits of the claim. I mean, that's the way I think Lord Justice Singh puts it. So if we read, for example, paragraph 68 of ZN, point, he says this: the point can be tested in this way. Suppose that for some entirely extrinsic reasons an appeal became academic, for example, if events occur in the appellant's country of origin which mean that it may be unsafe for him to be returned, even though the Secretary of State had not previously accepted there was such a risk. So in other words, it's not so much the timing of when the events happen or the development, but it's whether or not it's the decision to withdraw is sort of causatively linked
To the claim.
to the merits of the claim.
Yeah, no, I understand that point about the certificate. Does the same point apply to the detention claim?
But the detention claim doesn't fall, or isn't academic and hasn't fallen over. But the detention claim, liability for the detention claim has been admitted. So the only issue is quantum. And in terms of quantum, the appellant is entitled to argue any point the appellant wishes, save for the point as to whether the decision to detain was unlawful by virtue of Article 17 being in play at the time of detention. So anything to do with failure to look at the appellant's medical condition, anything to do with Hardyall-Singh general principles, anything to do with that, the appellant can argue. What the appellant can't argue is, well, yes, the Secretary has accepted that for one EU law reason, the whole period of detention was unlawful. But actually, there's another EU law reason. And that, with respect, seems to be precisely the same sort of academic argument that we're dealing with in terms of this appeal. Because if you look at Hamati, and if you could turn to Hamati.
Because in Hamati they said it doesn't really matter what the basis was,
it doesn't.
The tort of false imprisonment is the tort of false imprisonment. It doesn't matter why you falsely imprison somebody.
Absolutely. Absolutely. And if you turn to paragraph 88. So, well, perhaps 89 is makes the point more clearly. And the last paragraph, or the last sentence in that paragraph says, in this appeal, that effectively the EU law unlawfulness has the consequence that the decision to detain the claimants lay outside the boundaries of any permissible exercise of the power to detain conferred by paragraph 16.2 of Schedule 2. Now, all the Hardyall-Singh issues relate to the exercise of discretion under paragraph 16.2 of Schedule 2. So the finding, the Secretary's acceptance that the appellant's detention was unlawful because it breached Article 28, it accepts that the exercise of power under under paragraph 16.2 was unlawful. That's it. So why does it make any difference if it's also unlawful for another EU law reason?
And paragraph 91 goes on to make the point that the right to compensation is provided by the common law claim for damages for false imprisonment, which damages are compensatory, depend on circumstances, degree of harm the claimant has suffered by reason of wrongful detention. No reason to believe the impact of loss of liberty is likely to be affected because of the lack of legal authority as a consequence of failure to comply with EU or domestic legislation.
And carry on, in my judgment, the source of the lack of legal authority doesn't justify treating people differently. Otherwise, it doesn't matter.
It doesn't matter, no. So it's the impact on the individual, and the impact on the individual, as the appellant accepts, can be advanced.
Okay.
I'd also just make the point in terms of this, the suggestion of aggravated damages. I mean, it's not. There's no claim for aggravated damages in the pleadings as they currently stand, as far as I can see. And to be honest, I mean, it is almost inconceivable to see how you can or how a legitimate argument can be raised that the Secretary of State, in deciding, in terms of the Dublin unit, called the Third Country Unit, TCU, in deciding to return to Italy, acted so badly or inappropriately, given the Secretary, as I will show you, at least given the Secretary of State's understanding, of how the process worked, that it would justify some form of aggravated damages. I mean, every single decision that successfully challenged Dublin decision obviously reflects an error by the Secretary of State in terms of the approach to Dublin. What could possibly be said about this case, where on the Secretary of State's understanding, whether this court accepts it or not, but it's quite clear that on the Secretary of State's understanding, after the exercise of discretion, there had been no exercise of discretion under Article 17. Whether rightly or wrong, that was the Secretary of State's understanding. And indeed, as you've seen, it was the position that was maintained in the Secretary of State's submissions in FATI, that understanding could of itself justify an award of aggravated damages. And insofar as the appellant wishes to make some sort of complaint about the general conduct of the litigation, of course, that's not dependent on the outcome of this appeal. And this appellant, on one view, in terms of costs, is no different from a claimant who's privately funded and who is awarded costs, but not the totality of their costs. And therefore, some of the damages received has to be used, or if not all the damages, to pay whatever's been agreed with their solicitors. But I suppose the sort of the real point is that if appeals aren't academic simply because their impact on costs, then it's very difficult to see in what circumstances they can properly be considered to be academic. I mean, in this case, of course, there is no order as to costs, so we're in a different position from the ordinary circumstances of a party having been unsuccessful in the court below, where they've been ordered to pay their costs, ordered to pay the costs. In terms of HA minor, I'm not going to deal with it in any detail, but the paragraphs you referred to at 100, if you look at the next paragraph,
I think we refer to 122.
122, big one. If you look at the next paragraph, 123, so the over the comment really relates to a criticism, well, not a criticism, the judge expressing a view about the approach of the LLA.
Yes.
I mean, that provides no support really for.
Can you remind me where H is? I've managed to lose it.
Tab 15.
Thank you very much.
So it's one big one, 121. So you were taken to 120. And all the comments about just and equitable relate to, if you look at 121, about the approach taken in terms of recouping damages. And of course, this isn't an HRA claim either.
No.
I mean, this is just a sort of a standard detention claim. So in terms of an academic, we say this is really a classic academic case. Indeed, I'd go beyond that because it's very unusual to be dealing with an appeal in terms of regulations that are revoked, and that due to the passage of time, that there are no cases left in relation to which this issue could arise.
There are none.
No, I mean 31st of December was when the revocation, when the UK withdrew effectively from Dublin III, and the way that the revocation regulation.
Sorry, 31st of December
2021.
2021.
I'll double check. I think it's 20.
So that's when the United Kingdom withdrew from Dublin.
Yeah.
Right.
And then the way that the revocation regulations deal with it is that from that date onwards, no further claim can be made under Dublin III. And in relation to claims that predate the 31st of December, then only live claims under Dublin III continue to be considered. So by that I mean, if a response, if a request has been made and the response received,
Yes.
then that's it.
Well, how many of those are there?
Oh no! When I was advising on them, I don't know precisely, but I was advising on them on the approach in about May this year, and the number of live cases at that point was I think about, as far as I was instructed at that stage, were certainly under 50.
Okay.
But obviously, because of the tight time limits, they will have
They would have expired.
Even more shortly. And then obviously there's been a sort of general approach because of the difficulties in politics between the UK and the EU of
Yes.
a pragmatic approach being taken on in many occasions. So there is simply no benefit at all in terms of wider interest, or indeed in terms of in substance for the claimant.
Okay.
Right. The other thing, because I've got just 10 minutes, what I propose to do, subject to this court being content, is really just to deal with some of the queries that you raised, and then I'm going to deal with, perhaps after lunch, I can just deal with in a more structured way the Secretary of State's position.
Okay.
Yeah.
On the substantive issue.
Yeah. So I'm just going to deal, because you raised quite a few, not quite a few, big ones. The different vessels raised different questions, so I was just going to try and deal with the key ones that were raised. So the point was made repeatedly. There's no evidence as to why the letter was sent. Why
Yes.
the invitation letter was sent. With respect,
Oh, you said that report was raised by council, not by us.
yes, I beg.
But we appear to accept it
Yes, that's right. Absolutely.
by our constant reference to the footnote.
That's right. That's right. Can I try and explain the Secretary's position on that? And my friend, I'm sure will, if she disagrees with anything I say, we'll deal with it in reply. But it's common ground, and I think, my Lord, you noticed the fact that there are different addresses. Yeah? So the Secretary's position is that there's a unit called the Third Country Unit that deals with the Dublin process, and there's an asylum unit that deals with asylum.
Yes.
Now, just touching on that, if I can make good this point in terms of evidence anyhow, by the letter that was sent April 2011 informing the claimant, the appellant, that the claim was going to be considered in the UK.
2021.
2021. And that letter is colloquially known as a dropout letter. It's 310. And if you just read the sort of the first 3 or 4 paragraphs to yourselves, you will see that how the decision making is split.
Sorry, I think this is my fault. I got the wrong page.
Is it 310?
Oh, 310. Sorry, I misheard you. My fault. Thank you.
So what should happen if the asylum process worked correctly is that the asylum claim comes in, and I can take you through the GSID notes on this if necessary. The asylum claim comes in, a case is identified as a potential third country case. The case is transferred to the third country unit. The timeframes for any asylum decision are stayed. The third country unit makes a decision as to whether Dublin and carries out the Dublin process. The third country unit decides whether the outcome of the Dublin process requires a request to the responsible member state or for the case to be released or dropped out of the system, TCU system, to be considered substantively in terms of the asylum case by the UK asylum team. That is the way the process ought to work. And if you look at the GSID notes, you can see, as with everything, these notes are never clear, I'm afraid, but if you turn to 418.
Yeah, in the supplementary,
Yes.
well, not supplementary, the second half of the
And if you,
second half call. Yes.
so if you look at 418, you see the applicant is a definite TCU case. That should be towards the top.
Yep.
And then if you look in the middle of the page, the ASY category 4 delayed TCU flag has been applied to the case. This is because it is a TCU case, and until such time as it were dropout, the case is not subject to the usual timeframes. And although I accept it's not spelt out, the timeframes are the timeframes, and my learner will indicate if she disagrees. The timeframes are timeframes for determining the asylum claim. And that is evidence, clear evidence that the approach that should be adopted is TCU should consider the case. TCU, if this is the appropriate outcome of the Dublin process, issues a dropout letter. Article 4, as I'll show you, of the Dublin Regulations requires applicants to be notified of the outcome of the Dublin process. That's what the dropout letter does, where the UK has accepted responsibility. And then after the dropout letter has been sent, the file and the papers are transferred over to the asylum unit for the asylum process to commence. That is why in this case, the fact that before any dropout letter was sent, an entirely separate department not involved at all with the Dublin process making an invitation to interview was in error, because it's not the way the process should work. And there is with respect, there is evidence that in the GSID notes.
So, Mr. Payne, can you help me with this, please? How were the GSID notes produced? Was there a witness statement, or were they just disclosed in response to a data subject access request?
Well, there certainly wasn't a witness statement, but I'm not sure if they were disclosed in the course of these proceedings or as part of a data subject access.
Right. So when you say there's evidence, what you mean is that there's the GSID notes. That's all there is.
But in the context of a judicial review, I think that is evidence. I mean, is it not? It's certainly never been challenged, and both parties have relied on it. And certainly, in my experience in detention claims, that is the evidence the court bases its assessment of the detention reasons for. Insofar as there isn't a witness statement formally exhibiting the various GSID notes, I accept that there wasn't one. But all the various decision makers, the names and identity in the GSID notes have been redacted again, as is common. And certainly my understanding is there's no challenge.
So the evidence as you would call it, is these sheets from which you would invite us to infer that it was an error. There's no statement saying this was an error.
No, that I accept. No, there is no.
There was an assertion on 418 that it was a TCU case, and until it's dropped, until there's a dropout, it's not subject to the usual timeframes, and there is a dropout later, much later.
Yeah, and at the time the invitation for an asylum for the interview was issued, there'd been no dropout letter.
And nor is there any evidence that, I mean, you've been telling us what the process normally is and should be, but there isn't any evidence that that is what the process should be. You're inviting us to infer it from the two sentences on page 418.
Well, I was inviting you to take as accurate what was said at 418. It says this is a TCU case until such time.
Yeah, that's the point I've just made. Okay.
Yeah.
Could you help me with your footnotes, which I'm now scrabbling to find, just can't find, whether your footnotes are, because I wanted just to see how you put it. I think the footnote said that there was a mistake was made. Is that your inference based on the evidence you've just shown us, or was that on instructions?
It was on instructions.
Instructions from whom?
Well, from my.
Your solicitor, your instructing solicitor.
We obtained it through from the client.
It's a.
I mean and I appreciate the concerns the court indicate impressions, but the approach that was taken was effectively not uncommon in these kind of cases, where the identities of every single officer who took every decision along the way was redacted. So it was simply the court was being invited to proceed on the basis of these notes.
Mm. I mean, I think, for my part, I think what's in the footnote manifestly should be in evidence and not in a footnote.
Melody.
Just help me, was that a material that you've just shown us, was that behind the respondent's notice? Is that how it came in as part of your disclosure? That's, I'm sorry, you said
It's
it, but I
before
can't remember
that.
what you said.
It's
Was it
before
was
that?
it earlier?
Just
Part of
disclosure.
duty of candour, was it?
Yeah. Well, I did say I'm not entirely clear.
Sorry, I just missed it.
No, it's my fault. I'm not entirely clear. I'm not sure whether it came. It was disclosed as part of duty of candour or by reason of a subject access request.
Right, it's 1 o'clock, Mr. Payne. I think we'll break now, and we look forward to seeing you again at 2 o'clock.
Well,